There we go. All right. So Canada's anti-spam legislation, that's what we're here to talk about. And before I go and get into it, I just want to thank TechSoup Canada for inviting me and having me speak to all of you today, and certainly thank you all for taking the time to listen in. I hope it would be I'm going to try to be as informative as possible. I'm also going to, you will see, try to go as fast as possible through the slides, because I find tends to be a lot of questions at the end, and certainly my preference would be to try to answer all your questions in the time that we have. So I will try to speak not too fast, but also not too slow, to try to get through the information, because there is lots of it. The other thing you need to know, again, is if you have any questions, and I think Jane mentioned that, please write them out, and I will deal with them at the end, and hopefully this will go as smoothly as possible. So, Canada's anti-spam legislation. What I'm going to do today, I'm going to provide you with 4 things I'm going to talk about, give you an overview of CASL, or Canada's anti-spam legislation. I am going to talk about, in detail, about the commercial electronic messages, or CEM requirements in CASL. Those are the ones that are coming into force in July 1st, so there's only less than 5 weeks left, and they are what I believe most of you want to hear about today. I will give you some tips for preparing for CASL, very general tips that what I can cover in this short amount of time. And finally, I will very briefly at the end cover the other CASL requirements that are not CEM related. So CASL, what is it? Well, this legislation actually is not new. It's been around since 2010. It was passed in 2010 by Parliament to deal with a problem. Well, what was that problem? The problem was spam. Spam, we all get it. We all pretty much believe we know what it is. You know, it's those, and most people think spam is those annoying emails or pesky emails from a prince somewhere in Nigeria asking for you to donate or send them some money for a fantastic investment. Well, in 2010, when this issue came about and the government decided they want to do something about it, they tried to figure out, the big issue that came around is, well, what is spam? Is it really only those emails, or is it more than that? And just as an example, before this webinar, I went and I looked at my work email just to get an idea of what type of emails I got today. And just before noon, I counted about I had 23 emails that came in that were not substantive in any way. In fact, I pretty much could have ignored it. They tried to sell me something, they tried to promote something, and those 23 were out of the 38 I received by noon since this morning. So, a big significant portion of my personal email, my work emails, actually, I won't even get into my personal email account, are emails that I would consider spam. And so in 2010, what happened is that Canada was one of the only G20 countries that had not passed some form of anti-spam legislation. And in fact, to date, we are considered a haven for spammers and hackers. And so to illustrate to our G20 members that we are tough on spam, we are tough on hackers, we being the Parliament decided to pass this law, and what they did was, to solve the problem of spam, they decided to regulate everybody, not just those princes from Nigeria. And what they've done is basically they've created a regime that regulates all commercial electronic messages that are sent or accessed from a computer in Canada, and we'll get into what commercial electronic messages mean. But it's what this suggests, though, is that even though it's colloquially referred to as Canada's anti-spam legislation, it actually is in Canada a spam regulatory regime. It's more than that. It regulates many more types of activity, online and electronic activities. It also regulates other types of activities, including the installation of computer programs, misleading advertising and marketing practices, privacy invasion through computers, and finally, the collection of email addresses without consent, often referred to as email harvesting. In addition to that, and just to give you additional background, so when this legislation was passed in 2010, why are we talking about it now? Well, what happened is that there was a big uproar basically in every industry out there, including the charities and nonprofit industry, and saying, well, this legislation is extremely broad. There's got to be some tailoring. There's got to be made workable for the industry, for commercial practices. And so consultations were put out, and basically the government consulted with pretty much everyone out there, and everybody was lobbying for some form of exemptions, some narrowing of the legislation, etc. And finally, in December of 2013, regulations came out. Were put out by Industry Canada that tried to somewhat narrow the application, provide some exemptions, and make it what they believe to be workable. And they also provided us with the coming into force dates, one of which is July 1st, 2014. And so when these came out in December 2013, everybody realized suddenly that there's not very much time to prepare, and that's why we're here today. So in addition to passing these regulations, what the government has done is that it has made it very accessible and easily available for anyone to go ahead and complain about violations of CASL. The idea is we're available, you can come to us and complain. And what they've done is they set up this website, fightspam.gc.ca, and as of July 1st, 2014, anyone can go and file a complaint on that website. They don't have to go through a long bureaucracy of filing documents at an office. It's simple as clicking the mouse. So, CASL, when you think about CASL and all the types of activities that are being regulated, there really are two fundamental underlying principles. And those are basically that all these activities must be carried out with informed consent, okay? And there has to be clear identification of the sender. That seems very simple. However, what is also what makes CASL quite unique compared to most anti-spam regimes and differentiates it, for example, from privacy legislation, is that it's an opt-in regime. So in addition to the fact that you've got to think about these CASL as activities that are done with informed consent, that consent has to be opted in. It's not an opt-out consent. So they've passed CASL, and they've figured out, well, if we're going to do this, we have to make it serious. We have to show the world that we are not a haven for hackers and spammers. We got to give some kind of incentive for people to actually to comply. And boy, they definitely did that. And what they've done is they've provided significant consequences for noncompliance. The first thing they've set up is fines, regulatory fines, or administrative monetary penalties, as they refer to them. And basically, the Act provides for a fine of up to $1 million per violation for individuals, and up to $10 million per violation for organizations. It's not, I wrote corporations for lack of space, but it really is any type of organization and entity that's not an individual, so corporation, partnerships, etc. In addition to the regulatory fines or administrative monetary penalties, the Act also provides for private rights of action. Well, what are those? Well, basically they're lawsuits, civil lawsuits, and the Act provides that anyone who is a receiver of on the receiving end of a violation of CASL, so for example, an email that violates CASL, can sue the sender or the violator in court for damages. And the Act provides for significant damages per email. I'm not going to get into the numbers. It depends on the situation. But however, what you have to keep in mind is while one lawsuit is, maybe not so grand in damages, there's also huge potential for class actions, because one mass email sent to 1,000 people in violation of CASL ends up with a class action of 1,000 plaintiffs and potential for multi-million dollars in damages. In addition to that, and that's something all of you need to keep in mind, particularly when you're in a nonprofit and charities area, is that there are there's extended liability under the Act. First thing is there's vicarious liability of the corporation for an act of the employee, and just as important, there's personal liability for officers and directors for the acts of the corporation. So your executive directors, your board of directors, sorry, executive, yeah, your EDs, your board, members of your board of directors, even if they're volunteers, may face personal liability for CASL non-compliance. In addition, in order to be able to enforce this, the government has given the regulators, and we'll talk about who they are, quite sweeping, when I say sweeping, investigative powers. You know, if there is a complaint and they believe there's it's valid, they have the ability to go in and search, search computers, seize information, etc., in order to investigate and get some evidence in support of their investigation, their enforcement. So, coming into force. Well, the first important date is July 1st, 2014, which is very, very close by, and maybe only a few more weeks left. That date is important because that's when the requirements respecting CEMs comes into force, and we'll talk about what those requirements are in a minute. The next date is January 15th, 2015. That's when the requirements respecting computer programs come into play. So while it's a little bit further on, it's not too far away. And finally, July 1st, 2017. That date is important because, as I mentioned earlier, those private rights of actions, well, those, you know, that ability to sue doesn't come into force until July 1st, 2017. And basically what the government has said is, well, you know, we'll give you guys 3 years to avoid being sued in court, and, you know, we'll tell those plaintiff class action lawyers to hold off for another 3 years. But that does not mean that the government cannot go after you for a regulatory fine. It just means you can't be sued for another 3 years. In addition, they have provided for a transition period of 3 years for implied consent. I'm going to talk about that. That is very, very specific to certain circumstances, and doesn't mean that there's a transition period for compliance with CASL in its entirety. In fact, quite the opposite. This transition period that has been put into place is, you know, I find by speaking to people, and people, you know, in various industries, that there's a misconception out there that means that there's what people often refer to as a grace period to comply. That's not the case. You must start complying with CASL and the CEM requirements as of July 1st, 2014. There is no grace period for compliance. Regulatory body. So what the government has done is, because this act is quite broad, it decided to not task only one federal body with enforcing it, but 3. And so there are 3 bodies out there that may enforce various parts of CASL. The first and the main one is the CRTC. CRTC has the authority to enforce and to regulate the CEM component and the installation of computer program sections of CASL. In addition, the Privacy Commissioner has been tasked with enforcing the collection of personal information and address harvesting. And finally, the Competition Bureau has been tasked with enforcing the misleading online advertising and marketing practices. All right, well, that was the overview of CASL and its regulatory regime. I'm now going to get into the bread and butter and what everybody I believe are here to learn about, and that's the CEM, or the Commercial Electronic Messages component of CASL. Well, what is a CEM? Well, under CASL, a CEM is a message sent by any electronic means. So an email, a text, instant message, tweet, etc. Those are examples. That has as its purpose, or one of its purposes, to encourage participation in a commercial activity. So when you read this and you think about the fact that this is not just what you would, as I mentioned earlier, traditionally consider spam, it's more than that. It's pretty much any electronic message sent that has sufficiently one purpose to encourage participation in a commercial activity. And the CRTC has said, the government has said that purpose can be gleaned from, you know, must be gleaned from the wording of the message, but basically it's sufficient that you put in a hyperlink to a website. 2 words can turn an email into a CEM. So as long as there's some form of encouragement of participation in a commercial activity, then it turns into a CEM. Well, what is a commercial activity? Well, under CASL, commercial activity is any particular transaction, act, or conduct. So it's not only that there has to be a transaction. It's anything whatsoever that's commercial in character. So somewhat of a circular definition. In any event, you just have to think about it. That's pretty much anything within a commercial, has a commercial basis to it. And the other part of that definition, it's that the commercial character the conduct doesn't have to be carried out with the expectation of profit. Well, those words turn the definition of CEMs to electronic messages sent by charities and nonprofits, and that is very clear from the definition. Then the answer to the question is yes, do charities and NPO transmit CEMs? That's why you're all here, and that's pretty much the crux of the matter. I have given you some examples of what I would, very generic, basic types of CEMs sent by charities and nonprofits, but certainly there's so many more. Emails seeking donations, emails selling tickets to an event or lottery, emails promoting services. So long as those services have some form of commercial character, emails promoting a charitable event or activity, electronic newsletters. Now, newsletters, at least in my view, would be CEMs, but not always. It would certainly depend on what is contained in that newsletter. So if the newsletter contains information about the great activities conducted or about the organization, what it does, and those activities are somehow commercial in nature, then it would be a CEM. If the activities or the information in the newsletter is not commercial in any way, it's purely informational, it might not be a CEM. However, if at the end of that newsletter, at the bottom, there's a line that says, well, to find out more of our organization or to donate to us, please click here. Those 5 to 6 words turn it into the newsletter into a CEM. So newsletters, in certain circumstances, will not be CEMs, but often they are. And finally, emails promoting the organization and charity are likely CEMs. So now that we've discussed what CEMs are, and it's pretty evident that almost all of you or anyone listening today and their organizations will be sending CEMs at some point to someone. So then the question that arises is, well, what are the CASL's requirements with respect to CEMs? Well, basically, what CASL says is two things. First, it says that you cannot send a CEM to an electronic address unless the receiver of that CEM has already provided you with his or her consent to receipt of that CEM, and the CEM contains certain prescribed information. As I mentioned, these are the two main requirements of CASL: informed consent, opt-in, and clear identification of the sender. And we'll talk about what the information what exactly is that information supposed to look like. There are some exclusions and exemptions, and we'll talk about those later, but that is the general requirement regarding all CEMs. So let's talk about the consent requirement, the first part of the CEM requirements. Well, consent, CASL says that CEMs may be sent with either express or implied consent. So there's two kinds of consent. And importantly, the onus of proving consent rests on the sender. So if at some point you're facing a regulatory investigation or a complaint, it will be up to you to prove that you got consent to send this person the CEM. It's not the other way around. What CASL has also done is it has made it very clear that post July 1st, 2014, an electronic message sent whereby you are requesting consent under CASL is a CEM and is therefore prohibited. So what does that mean? Basically, after July 1st, 2014, you cannot send out an email saying, please give me consent to send you CEMs. If you do that, you're violating CASL. let's talk about consent. Well, there's two types of consent, as I mentioned, express and implied. With respect to express consent, the CASL has very specific requirements that you need to meet in order to rely on the express consent. And the first thing it says is, well, you can get express consent orally or in writing. Okay, so it could be by telephone, it could be in writing, but as a lawyer, I always say better in writing, always better to have a paper trail, of course. And your request for that consent has to meet certain requirements. First of all, you have to state the purpose of for which you're seeking consent clearly and simply. So it can't be ambiguous. It can't be confusing. Clearly and simply. It also has to be specific for the type of consent you're seeking. In other words, it has to be informed. What does that mean? Well, having a statement that says by clicking here, you hereby give us your consent to us collecting your personal information and disclosing it as in accordance with the law, which is a lot, which is basically what most people have in their under their privacy policies. That is not sufficient for CASL, because what you're not doing is seeking consent to send CEMs. So it has to be specifically state that you're seeking consent to send CEMs or certain types of CEMs. So it could be, by clicking here, you consent to receive our newsletters. By clicking here, you consent to receive, make it as broad as possible. You consent to receive all electronic messages from us, and so forth and so on. It depends on how broad or how narrow you want to tailor it. The other thing you have to do when you seek express consent is you have to identify yourself. You have to identify the organization or anyone else on whose behalf you are seeking consent. And you have to state that the receiver can withdraw their consent at any time. I listed here some examples of proper forms of consent post July 1st, 2014. First of all, paper form. Bottom line is, because of that requirement and the statement that you cannot send an email seeking consent under CASL post July 1st. The best way to do it is get it in writing, hard copy. Another way to do it is electronically, but you cannot do it in the form of a CEM, as I mentioned earlier, and you cannot include a pre-check box. That's something the CRTC has been putting a lot of emphasis on for whatever reason. They have a grudge with pre-check boxes, and they say that post July 1st, 2014, you cannot seek express consent by having a pre-check box on the screen. So make sure that if they're pre-checked and whoever's going to be designing this for you, that check mark has been removed post July 1st, 2014. You can do it on your website. So you can have a section on your website where people can go and sign up to get CEMs. And finally, you can do it orally. So you want to send something to someone, there's no other way but around it. You can give them a call and say, hey, can I send you CEMs? And I'd always suggest to follow up by asking them to send that to you in writing or by email. So that's basically the overview of express consent and its requirements. As I mentioned earlier, there's another form of consent that you can rely on to send CEMs, and that is the implied consent. Okay, and implied consent under CASL is not the same as implied consent under the privacy legislation. So if you're familiar with implied consent under privacy legislation, you have to do a switch in your head. It's not the same thing. Okay, and please make sure that that's a very important distinction. Basically, my understanding is under PIPEDA, implied consent is more of a circumstantial situation. It depends on the relationship, and it really depends on the actions of the person who has given, or who you say has given you consent to under PIPEDA. Under CASL, there are very specific requirements in order to meet the implied consent situation. Okay, so if the relationship or the circumstances meet these particular specified requirements, then you can rely on implied consent. Otherwise, there's no other situation where you can rely on implied consent. It either meets these requirements, or it doesn't. If it doesn't, you don't have implied consent. In a way, it makes it simpler, but also makes it very much more difficult to rely on implied consent than it is under the privacy legislation. So the first situation where you can rely on implied consent is when the recipient of the CEM has, first of all, conspicuously published his or her electronic address. So, for example, on a website. I always give myself as an example. I have my bio on my website. Right next to my bio, there's my email, and nowhere on that website do I say, please don't send me CEM. So that's the second requirement is the person cannot have indicated the desire not to receive unsolicited CEMs. And finally, and most importantly, the message of that CEM has to be relevant to the recipient's business role, duties, or functions. So to go back to my example, if it's me that you are trying to send a CEM to, you can rely on implied consent, only that you have my implied consent to send me that CEM, only if the message, the actual CEM, is relevant to my business or role as a lawyer. So if you're trying to sell me a service that's relevant to my work as a lawyer, great. But if it's something unrelated to that, then you cannot rely on implied consent. Similarly, there's another situation that's quite similar. That's a situation where you have implied consent when the recipient has disclosed to you his or her electronic address without indicating a wish to not receive unsolicited CEM. So, for example, I refer to this as the business card situation. You've met them at a trade show. They gave you a business card. On the business card, there's an email, okay? And they didn't say when they gave you the business card, please, here's my business card, but please don't send me electronic messages, which is unlikely. So if you have that business card, great, you have implied consent, but only if the message of that CEM is relevant to that person's role or duties in business or official capacity. So again, it has to do, you can only rely on it if the content of the message is relevant to the receiver's duties, business or duties. The other form of implied consent, which is what most non-profit organizations and charities, I believe, will be relying on, is what is referred to as a non-business relationship. So under this, in this circumstance, you as a non-profit organization, actually, if you are a registered charity, which is, defined similar as it's defined in the Income Tax Act, you have implied consent to send a CEM to anyone who has made a donation to you or perform volunteered work for you in the preceding 2 years. Okay, so as long as this individual has donated to you or has volunteered for you in the past 2 years, you're good. You have implied consent for 2 years. However, once those 2 years are over, so is the implied consent. Similarly, if you are a non-profit organization, and that's defined very similarly to how it's defined in the Income Tax Act, you're not a registered charity, you have implied consent to send CEMs to anyone who has become a member or has been a member of yours in the preceding 2 years. And one of the questions I did a similar webinar yesterday, and one of the questions I got is, well, how does the CASL define member? Well, to answer that question, membership is defined in CASL as a status of having been accepted as a member of a club, association, or voluntary organization in accordance with its membership requirements. So it's pretty broad. As long as you have specific requirements that set out how someone could become your member, and that person has become a member in the past 2 years, then that person has given you essentially implied consent to send them CEMs for the next 2 years. But however, keep in mind, as soon as those 2 years are over, so is the implied consent. Another form of implied consent, which is what more the for-profit businesses are going to be relying on. It's quite similar to the non-business relationship, and frankly, it's also pretty relevant to charities and nonprofits, is the existing business relationship implied consent. And what that says is, if in the 2 years prior to the sending of the CEM, again, so it's a 2-year period, the recipient had purchased, leased, bartered a good, product, service, or land from the sender, or accepted a business investment or gaming opportunity offered by the sender. So for example, bought a lottery ticket from you, or has entered into a written contract with the recipient, sorry, between the recipient and the sender, then there is implied consent to send CEMs for the next 2 years. But again, that 2 years, once that 2 years is up, so is the implied consent. That 2 years is shortened to 6 months for any messages that are sent to someone who has sent an inquiry application about one of the items above. So, if for example, someone has applied for a good service, etc., or has made an inquiry about it, you send them the information, but then they change their mind, didn't want to go ahead with the purchase, you still have 6 months to send them CEMs. After that, the implied consent is over. One more thing to know about the implied consent with respect to the non-business relationship and the business relationship. As I mentioned, it has a finite period. Under the Act, that finite period is 2 years. However, in order to give nonprofits, organizations, charities, and businesses some form of reprieve, what the Act has done is it provided for a 3-year transitional period starting in July 1st, 2014, extending till July 1st, 2017, for that form of implied consent. In other words, basically what it says is those 2 years are extended to 3 years at the get-go. After July 1st, 2017, it goes back to 2 years. So all this means with respect to the transitional period is that implied consent, instead of 2 years, you have 3 years at the beginning. It doesn't mean for other types of form of relationships, in other words, when there's no implied consent, it doesn't mean that you have 3 years to comply. Right, so that's basically the overview of all the requirements with respect to consent, both express and implied. As I mentioned at the beginning, there's another requirement with regards to CEM, and that is the information requirements. CASL says that all CEMs must include identifying and contact information of the sender, or the person or the organization on whose behalf the CEM is being sent, and the contact information needs to include the sender's address, as well as a valid email or phone number, and any other type of identifying information. It has to provide a means by which to contact the sender, which is valid for at least 60 days. So, for example, if you include a phone number, that phone number has to be good for 60 days. If you include an email, that email has to be that the person can reach you at that email for the next 60 days. And finally, an unsubscribe mechanism, which is very important, and we'll talk about what that means in a minute. Now, because this is quite onerous, and not all organizations can do this, CASL said, well, we'll give you a break. We're basically going to say, well, if it's not practicable to include all this information in all CEMs, well, what you can do is you can post it on a website, and then you must include in all CEMs a link to that website, which is clearly and prominently set out in the message and is readily accessible. So, if you're, for example, a small charity, a nonprofit, and starting to overhaul all your emails by including this information and including an unsubscribe mechanism in each and every email is going to be too costly, for example, I would say, and it's not just simply not practical. Then instead what you can do is you can go to your website and create a page where there's all the identifying information as required, as well as an unsubscribe mechanism, and then a link to that page has to be included in each and every one of your CEMs. Well, the unsubscribe mechanism. So what is that? Well, first of all, it's a means by which the receiver can opt out. Okay, that's basically what it is. And there are certain requirements. So first of all, that unsubscribe mechanism has to be effective for 60 days. Okay, so at any time, within the 60 days after the message is sent, the receiver must be able to go to the follow the unsubscribe mechanisms, whether it's going to a website and clicking on something, whether it's just clicking a checkbox, whether it's sending an email and saying unsubscribe, whatever it is, the mechanism that you set out. That has to be available for 60 days after the sending of the email. The other important part of it is that you have to give effect to the request, the opt-out request, within 10 days of the request. So at some point, once those 10 days are over, you cannot send any more further CEMs to the person who unsubscribed. And conversely, if someone unsubscribed, you still have 10 days to send them CEMs. And finally, you have to make it at no cost to the requester, no cost to the requester. Sorry. Exemption. So before we go ahead to the exemptions, I'm basically going to summarize and say, when you think about CEMs, what you got to think about is two things. Again, you cannot send it without having first obtained consent, either express or implied, and you must include the information and subscribe in all CEMs. Now, exemptions for CEM. So as I mentioned early on, there are certain situations where you are exempted from complying with these requirements. You don't have to get consent, and you don't have to include the information requirements. If you meet those particular situations, well, that's great, right? You don't have to do any of that, but you got to make sure you do. So let's talk about what those exemptions are. The first one is the registered charities exemption, and that's if you are a registered charity, you are lucky. If you're a nonprofit organization, but you're not a registered charity, you cannot rely on this exemption. And what it says is that any CEM sent by or on behalf of a registered charity is exempted if the primary purpose, the message has as its primary purpose raising funds for the charity. All right. Well, what I want to emphasize to you is the words primary purpose in this definition. What does that mean? Well, first of all, you have to, when you're trying to think about what primary purpose means, you've got to think about it in relation to the broader definition of a CEM. The CEM is defined as such, a message becomes a CEM, right? Like an email, for example, becomes a CEM when there is at least one purpose of encouraging participation in a commercial activity. But to be exempted from the requirements of the consent requirements, then the primary purpose of that message has to be for the purpose of raising funds for the charity. So, keep it simple. To make it as simple as possible, you got to make sure that the information or the statements that are made in that particular CEM make it clear that they're for the primary purpose of raising funds and not for something else. Or in other words, put the ask first. So I give some examples here of situations that are not so black and white and a little bit gray. And for example, so an email that provides information about the charity's work and contains one sentence at the bottom asking for a donation. Is it for the primary purpose of raising funds? Since this is a webinar, and usually I ask the questions and see what people think. I'm going to answer it and say, I don't think it is. I think it's probably not, okay? Because the person who's reading this email, who is receiving it, is looking at it and saying, well, it's telling me all this great stuff about the organization. It's not really for the primary purpose of raising funds. It's for the primary purpose of educating me on the organization. On the other hand, an email that sells tickets to a charitable event, and if upfront it says, "Hey, buy these tickets to our this dinner that we're having to raise funds for whatever cause it is it for the primary purpose of raising funds?" If it's clear from the message that that's the only reason you're sending that email, it probably is. Well, what does raising funds mean? Well, a lot of people in the industry have asked and are asking, including myself, well, is it any different than fundraising as interpreted by the CRA? The word fundraising under the Income Tax Act has very specific definitions and is very narrowly defined, or not, I wouldn't say very narrowly, but it's very specific under in the manner in which the CRA interprets it. And certain activities, commercial activities that are carried out by charities are not always fundraising. Well, the question then arises, well, is raising funds under CASL the same as fundraising? And the answer is, we don't know. This legislation hasn't come into force yet. There's a lot of uncertainty on how it's going to be interpreted, how it's going to be enforced. And unfortunately, the CRTC is not being helpful. We've put this question to my colleagues and myself have put this question to the CRTC. I haven't received any guidance. I certainly, in all the publications that the CRTC has put out, they haven't guided with respect to whether or not there'll be a difference between raising funds and fundraising. What the CRTC keeps saying in response to these type of questions is, well, it will be considered on a case-by-case basis, which makes it completely entirely impossible to come to some kind of an understanding of what they really mean. And frankly, my belief is they just don't know. However, to make it somewhat easier on you, what I say and what I tell my clients is that, in my view, the CRTC is likely to focus less, and this is just an assumption. I'm going to say this right now. It's not legal advice because I frankly don't know, but I believe the CRTC is likely to focus less on the intended use of the funds, what they're going to be doing with the money, and more on the content of the message. Okay, because really, at the end of the day, this is a legislation that deals with communications. It doesn't deal with money, it's not supposed to regulate money, unlike the Income Tax Act. It really deals with what is the content? What does the message say? What is the message that you can glean from reading the words of that actual email? And in my view, primary purpose is likely to be interpreted from the point of view of the receiver of the email and not the sender. Why? Because this is a consumer protection legislation. So while when a lot of charities say to me, they say, well, all the emails we send out are for the primary purpose of raising funds. That's the whole point, right? But that's your intention, is the person, you have to ask yourself, does the person on the receiving end of that email really get that from the content of the email? Is that pretty clear that that's what you're asking for? You're asking for money, or you're really trying to do something or are you communicating something else? And that's where the test, in my view, is going to lie. Well, that's the charities exemption. Before I go on to the other exemptions, basically what you should take away from this is that if you're a registered charity, you are not exempted from complying with CASL, because unfortunately, the way that the exemption is worded, it is such that it likely won't apply to all your CEMs. There are going to be certain types of CEMs that are not going to be appear at least for the primary purpose of raising funds. And if that's the case, then you're not exempted. Well, if you're not exempted for certain types of CEMs and you're a charity, or if you're not a charity or a nonprofit organization, you still have the option of relying on other exemptions under the Act. And so I'm going to quickly go through those exemptions, because there's lots to cover, and again, I want to leave time for questions. So the first exemption is the personal or family relationship. Well, basically what that means, it says, is that you are exempted from complying with the consent requirements and the information requirements for emails sent to someone with whom you have a personal or family relationship. Well, I put personal and family in quotation marks because both of those are defined in the Act, and they're defined very, very narrowly, not what most people would consider a personal relationship or a family relationship. As an example, I always say your cousin, or even your second cousin, or even your cousin will not be a family relationship under CASL. And he or she you might have a personal relationship with, but under CASL that may only apply if you've had an ongoing two-way communication and it's personal in nature. And so if it's a cousin that you haven't spoken to in 2 years, well, it's likely not going to be considered a personal relationship. That's how that's the unfortunate circumstance of this particular exemption. Another thing you need to know is the CRTC has repeatedly stated that it does not consider relationships on social media to fall under this exemption. So your Facebook friends you do not have a personal relationship with them under CASL. Your Twitter followers, there's no relationship there, no personal relationship there, and certainly your LinkedIn contacts, you do not have a personal relationship with under CASL. Then another exemption that you may rely on is a CEM that consists solely of an inquiry or an application. So if you're sending someone an email or inquiring about something or applying for something, that's okay. You don't have to get consent. Solicited CMs. Well, CASL is all about unsolicited electronic messages. And so basically what you have is a simple exemption that says, well, if the CM is sent in response to something, in response to a request, in response to an inquiry, a complaint, etc., or is otherwise solicited by the person on the other end, well, that's okay, which of course makes a lot of sense to everybody, but they had to include it in there for whatever reason. Also, from a more practical perspective, it's unlikely that if you're responding to someone, they're going to go and complain about you for sending them a response. Internal CM. So this particular exemption is also, unfortunately, very narrowly construed. And what it says is it's okay to send CMs to someone within your organization in a business. Oh, that's all great, except that CM is only exempted if it concerns the activities of the organization or business. So you cannot send, or you or someone, there's no exemption for CM sent within, between, let's say, employees of an organization if it doesn't concern the activities of that organization. And as an example, and I always give this an example when I talk to charities and nonprofits, I give an example in my law office. So, certainly emails sent between our employees about various matters dealing with the firm and the law, sure, that's okay. But if an employee sends an email to all the people at my office or his or her coworkers, asking them, for example, to join her or him in a run to raise awareness for breast cancer, for example. And this is a law office. Obviously, that's not part of our activities. Then that would be considered not in compliance with CASL, and it would not be exempted. In fact, it would be a violation of CASL. And what, unfortunately, the way CASL is drafted is not only is that individual who sent the email liable, but it's potentially there's potential liability for the law office if someone complains, and as well as the organization on whose behalf that email is sent. So the organization for whom the volunteers are being sought. Another exemption, also quite narrow, is the organization to organization or business to business exemption. Sounds pretty innocuous, but it unfortunately isn't. What it says is that you are exempted from the consent requirements and the information requirements if there is an existing relationship, some form of an existing relationship between yourself and the receiving business or organization, and the CEM concerns the activities of that receiving business organization. So it has to do, again, with their activities, their business, and not your own. Another exemption is CEM sent to enforce a legal right. That's the type of exemption that I would be relying on quite often. Another exemption that, well, unfortunately is very strangely worded, and it's not necessarily clear how far it extends. But basically what it says is that you're exempted from the requirements if the CEM is sent within an electronic platform where the unsubscribed and identifying information is conspicuously published and readily available. I read in there within an example within a social network. So I read that as applying to social media and social network, but unfortunately the CRTC hasn't, and the CRTC has said that the CEM requirements will still apply to electronic messages sent using social media in certain circumstances. What does that mean? Again, they haven't been clear, but what is gleaned from what they're saying is that if there is a electronic message sent using, let's say, for example, Facebook, LinkedIn, etc., externally to an email address, for example, outside of using social media, but outside of social media, then you're not exempted. But if it's within the actual platform, within the actual social media site, like posting on someone's wall, tweeting and not the tweet doesn't go to this person's email, communicating within LinkedIn, and so long as that particular social media conspicuously publishes the information and an unsubscribe, you identify the information and an unsubscribe, then that's okay. Well, if you go to Facebook and you go to LinkedIn and you go to Twitter, it doesn't really comply with these particular requirements. And in fact, I'm not sure what the social media sites companies are doing right now, but I understand that they're trying to figure this out themselves. Another type of exemption, CEM sent within a limited access secure account by the person who provides that account. So this is for banking portals, okay? So if your bank wants to communicate with you through a secure portal. Another exemption is CEM sent by a political party for the primary purpose of soliciting contributions. So political parties have to comply, but they are exempted if the emails are for the primary purpose of soliciting contributions, very similar to the registered charities exemption. You're exempted for CEMs that are sent to a foreign jurisdiction. However, CASL says that if you are going to send a CEM outside of Canada, you have to make sure that you comply with the anti-spam legislation of that foreign jurisdiction. And if you don't comply with that anti-spam, the foreign anti-spam laws, then you would be violating CASL in Canada and can be regulated for that here. Another thing that's okay, oh thank goodness, is two-way voice communications. We can talk to each other on the phone. That's fantastic. That is not covered by CASL. And finally, faxes and voicemail messages sent to telephone accounts. So I always say you can't send an email blast, but you can get a robocall out there. Again, you might be in violation of the do not call list, but that's not for today. In any event, at least under CASL, you would not be liable if you send a fax or if you call and leave someone a message. There's a few other types of exemptions. Again, I'm going to go through these very briefly. What these are essentially are situations where you do not have to comply with a consent requirement. So you don't have to get consent to send these type of CEMs, but you still have to include the information and the unsubscribe in the CEMs. And these are, I listed them there. Basically, the first one is a third-party referral, and actually this is one that everybody should be aware of. It's like a bit of a reprieve for someone who, when you're trying to contact someone to whom you have been referred by another person with whom you have a relationship. So myself and let's say Jane at TechSoup, we have a relationship. I have consent to send Jane CEMs and vice versa. Jane has a relationship with someone else, and she knows that that person that might be someone who would be who I would be interested in contacting. She calls me and says, "Oh, that person I spoke to, you should contact them, etc., etc." I have consented to send them CEMs. I being Jane, she has consent. I have a existing relationship with them. You should contact them. And so I can send an email to that person, and in that email, first of all, I have to identify myself and include an unsubscribe. I also have to identify the person who referred me to them, which is Jane in this hypothetical circumstance, and I also have to say that that person may unsubscribe from receiving any further CEMs from me by either contacting Jane or contacting me. And if they do that, either way, that it has to be implemented. And also, importantly, with the third-party referral is that you only have reprieve for one email. So if I send that email out with the referral, and the person on the receiving end doesn't respond and doesn't follow up and doesn't give me additional consent, then I can't follow up anymore, because at that point I don't have consent. And other forms of situations where you can send an email without consent, but still have to include the information and subscribe, or emails that provide a quote or an estimate in response to a request. Warranty, we call it product safety information emails. CEMs that deliver a product or service. CEMs that facilitate or confirm transactions. So someone has donated to you, you can send them a CEM saying, and they haven't given you consent to do anything more. So, and frankly, if they donate to you in any event, you have implied consent, but no matter what, it's just an example. It doesn't have to be within those 2 years. You can send an ECM saying we confirm this transaction, although granted, if someone donates to you or buys something from you, you want to confirm that immediately. And then, of course, CEMs that provide factual information about ongoing subscription, membership accounts, etc., ongoing use or ongoing purchases, employment relationships, etc. So all of those you do not have to get consent for. All right, so we're coming up to the hour, and before I get into the tips, briefly review the tips. What I've done for you is I have put together a flow chart of how you want to think through these issues. And I've covered a lot of information, and I'm sure you're all scratching your head and saying, oh my God, what do we do? Well, what I've done is I've put together, again, I'm going to take you through the flow chart, and hopefully it will provide you with some form of a roadmap on dealing with CASL. So the first question you have to ask yourself when thinking about CASL is, do you send CEMs? And if the answer to that is no, which is very unlikely in my opinion, well, great. No further action required. You can go by your day and enjoy yourself. If the answer to that is yes, which is most likely, the next question you have to ask yourself is, are you a registered charity? If you are lucky, because it's your lucky day. You may be exempt from complying with the CEM requirements, but only if the primary purpose of the CEM is to raise funds for the charity. Well, if the answer to are you a registered charity is no, or on the other hand, you're unsure whether you're exempt because it's not for the primary purpose of raising funds, the next question you have to ask yourself is, well, maybe am I exempt under some of the other exemptions? And on the left-hand side, the left-hand box, I wrote an example of some of those. It's not all of them. It's just an example. The others are listed in the previous slide. If the answer to any of those is yes, no further action required. Again, you can go by your day. It's all good. You can send that. Oh, and of course, you can send your CEM. If the answer to any of that is no, well, the other question will be, does it meet any one of these other circumstances on the right? And if the answer to any of that is yes, well, you don't have to get consent. You can send your CEM, but you still have to include your identifying information and your unsubscribe. If the answer to any of those exemptions is no, the next question you need to ask yourself is consent implied? Can I send this because I have implied consent? Well, there are and I gave you the circumstances of implied consent, but the most common ones are basically what you have to ask yourself is, are you a registered charity or a nonprofit? And the recipient of that CEM has been a donor, volunteer, or member in the preceding 2 years. If the answer to any of that is yes, then you've got 2 years. You can send that CEM for 2 years from the moment they joined, they donated, they volunteered, or they became a member. However, you still have to include the prescribed information and the unsubscribe. And what I also recommend is you keep track of those 2 years, because once those 2 years are over, and so is the implied consent. And as another tip that is added at the end, I suggest you obtain express consent before those 2 years are over, because once you have express consent, once they actually said yes, send us further information, then you don't have to, you don't have to look at the clock. That express consent is indefinite until it is withdrawn. If the answer to no is implied consent, no, or you're not sure, well, in a very, very brief way, what I recommend is, first of all, before July 1st, 2014, try to get express consent from as many people as you can. And second of all, you have to make sure you include prescribed information and unsubscribe mechanism in all CEMs. I say before the July 1st. What I mean is you want to try to start that now, that process now. But certainly after July 1st, 2014, you cannot send the CEMs without having first obtained consent. And I write that in prescribed form because, as you recall, there are certain requirements with regards to how that consent needs to play out. And second of all, you have to make sure you include the ID and the unsubscribe in all your CEMs. Okay, so tips for preparing for CASL. And again, that flowchart is a roadmap, and it's just the beginning, but there's so much more that you can and should do to prepare for CASL. So the first thing is get your board on board, okay? All decisions respecting CASL should form part of the organization's overall risk management strategies. Why do I say that? Well, first of all, as you heard in the beginning, there are very serious consequences for non-compliance. I mean, we're talking millions of dollars potentially in fines, civil actions, et cetera, and as well personal liability. So if you don't get the board's attention, if you don't get your executive's attention, remind them, directors and officers' liability. They may be personally liable. Also, because this is there's a significant risk involved in this, they need to be involved in the decision-making process. It can't be left to someone who doesn't have the ability to take on these type of considerations, or the authority actually. Tip number 2: conduct an audit. Okay, so when you start thinking about this and what am I going to do, I always recommend sit down and audit your electronic communications. Try to figure out what forms of electronic communications does your organization use to communicate with internal and external parties. Once you do that, you have a better understanding on how you can put in a compliance program. So some of the examples of the questions you need to ask yourself, and again, this is just an example, you should ask yourself on behalf of which entities do you send electronic messages? Because don't forget, you may be liable for stuff you send on behalf of other parties. And conversely, what third parties are sending electronic communications on your behalf? Because you may be liable if they send something on your behalf and they're not in compliance. You need to figure out to whom you send electronic messages, of course, because that would be very important to determine, for example, whether you have implied consent and or whether you meet some of the exemptions. What do those communications contain? That goes to the basic question of whether or not it's a CEM in the first place, or alternatively, whether or not you meet the Charities exemption. And finally, what is the purpose of setting the electronic communications? Of course, that goes to whether or not it's a CEM, and of course, and the Charities exemption. Tip number 3: develop and implement CASL compliance policies and procedures. I put that in bold, in big font because it's very important. The reason it's important is because under CASL, you have what is referred to as the due diligence defense, and it's a complete defense to CASL violations. And what it says basically is if there is a complaint against you because of a violation of CASL, and it turns out it was in violation of CASL because someone sent out an email which went to someone with whom they haven't received consent, for example, or for whatever reason the information the proper information was not included, or the unsubscribe mechanism didn't work. Well, if you can show that you have done your due diligence by setting up a reasonable compliance policy that fits your type of communications and your type of organization and makes sense, it's reasonable, then you will be able to rely on the due diligence defense. But if you don't have that compliance policy in place, if you don't have proper procedures to make sure that you are complying with CASL, then that due diligence defense won't be available to you. Examples of stuff you need to think about when you develop these compliance policies are you need to think about developing policy procedures for requesting, maintaining, and implementing consents, keeping track of implied consents, and implementing unsubscribe requests. And also, I also recommend is developing and implementing CASL compliant language. So also for your policies, your procedures, as well as the various types of communications, whether it's putting languages that would meet the primary purpose exemption, putting language to meet the express consent requirements, putting in language in your third-party contracts, etc. Oh, sorry, I just dropped. Tip number 4: it's all good if you have a compliance program in place, but if no one knows about it and doesn't follow it, then of course it's useless. So the other part you need to do once you put the policy in place is train and educate management about CASL's requirements, as well as on your compliance policies. And I said management, but as you can see, I meant everyone: management, employees, and volunteers. Anyone essentially who is communicating on your behalf or it has any involvement in the organization should be trained and educated on CASL and your compliance policies. I would recommend develop a training program, particularly for the individuals who are regularly communicating on your behalf. Make sure your new hires or volunteers receive training. And finally, consider training third parties that are sending CEMs on your behalf. So for example, quite often these type of communications are outsourced to marketing bodies, to various communications bodies where it's I forgot the name of the service, but there's one service, for example, that sends out just blast emails for certain types of organizations, that kind of stuff. These are third parties. You need to make sure that they are actually complying, and to do that, you may want to consider training them on your policies. And while we're talking about third parties, the next thing you should need to think about is you got to look at your contracts with these third parties, and you have to make sure to require CASL compliance if they're communicating on your behalf, and I also recommend including indemnification provisions in case of non-compliance. Another tip I provide is consider buying insurance for CASL. Well, that's more of a practical tip. You don't have to get insurance, but given the risk, you may want to consider it. And finally, and that's very important, consult with IT specialists. If you have internal IT people, great, you're lucky. Most organizations, particularly the smaller ones, don't. And even if they do, those IT people are not qualified or do not know the requirements that are going to be, or may not be aware of the requirements with respect to CASL compliance. So at the end, I'll give you a website of one of the IT consultants that I have worked with and have I know have put into place some CASL compliant structures for charities and nonprofits. Okay, so those are my tips. Again, a very short version of my tips. There are, of course, many more ways that you can prepare for CASL, but that's just a starting point. Before we're going to go, and I'm going to take, I want to do 2 minutes to cover the other parts of CASL. Very, very briefly, because then I'm going to try to spend the last 20 minutes answering your questions. So as I mentioned, there's a few other areas that CASL, other than CEMS, that CASL regulates. The first one is the installation of computer programs. The second one is unauthorized electronic collection of personal information, unauthorized meaning without consent. Email address harvesting, which is essentially that code out there that basically goes out there and collects emails and then uses those email addresses to target people with CEMS. And finally, the prohibition against misleading marketing and advertising in electronic format. In here, I detail the computer programs requirements. Those come into force in January 15, 2015. I'm not going to get into them today because I do want to answer questions. But please, I ask you to read it. I set it up. But the bottom line is, what it says is essentially is you cannot install a computer program such as an app or a software on any computer device, including phones, tablets, etc., in Canada unless you have the express consent of the person to actually install those. Okay, and that consent has to be informed. They have to understand what they're doing. Okay, I'm going to move on. And again, if you, I implore you to read some of that. Okay, electronic collection or use of personal information. Basically, what CASL does, it prohibits anyone from using electronic systems to collect and use personal information and email addresses without the express consent of the person whose information is collected or used. So my recommendation is if your online marketing strategy performs any one of these functions, you should consider either eliminating the practice or obtaining consent to do it. So how can I help? Well, how can we help? Because, essentially, but I listed some of the stuff that I do, and certainly some of my colleagues do. I audit auditing of current and future practices. That's assistance with the audit, providing advice on implementing CASL compliance, drafting and reviewing compliance policies, procedures, and documentation, drafting and review of third-party contracts, compliance training, representation before regulators and courts. If you are on the unlucky situation that you are actually subject to a compliance enforcement, sorry, CASL enforcement. And finally, IT consulting. That's not me, but I gave you, as I mentioned, I will give you MethodWorks Consulting as one of the companies I have certainly come across that does IT consulting for CASL. Resources and updates. Okay, so I put my Twitter handle there, @ManidZemel. @ManidZemel. I also have @CASLLaw, though @ManidZemel is probably the one I use the most. I often publish updates, various things I write up about CASL are going to be there. So if you follow me, you'll get that information. I also gave you some websites, the CRTC's website, Industry Canada's website, and once in a while they, unfortunately not often enough, they put on some information. The website I provide there has on the CRTC website, .gc.ca, etc., CASL/. That one has the CRTC has published recently a frequently answered questions, which may give some guidance and answer some of your questions, although unfortunately none of those really apply to charities and nonprofits.
Okay, so I think we're running out of time here, so we're just gonna wrap up now. Manit, I think people can email you if they have further questions. And
Absolutely.
again, this webinar is being recorded, so we will be able to send the recording of this webinar as well as the presentation to everyone afterwards. So I want to thank everybody for attending the session with us today, and thank you very much, Manit, for giving us such a detailed presentation.
My pleasure.
Thanks, everyone.
Thank you, everybody, for attending. And thanks, Jane. Take care.
No problem. Thank you. Bye-bye.
Bye-bye.